Next case to come before the court is Kitson versus Gordon Food Services. Good morning.
Good morning.
Each side will have 15 minutes, and you as the appellant may reserve up to 5. Just let me know.
Good to see you. I would like to reserve 3 minutes for a vote.
That's fine. Thank you.
My name is Mark Owens. I'm the attorney representing the appellant, Tyler Kitson, in this appeal. This appeal arises out of the trial court's plain error in including an element of proximate cause in its instruction to the jury on the civil battery claim, its abuse of discretion in failing to award any cost to appellant as a prevailing party, and finally, its abuse of discretion in permitting defendant Ashley to file an answer to the appellant's first amended complaint nearly 6 months after the answer date. I'd like to address the plain error first. As this court's aware, plain error is reserved to those exceptional circumstances where there's no objection made at trial and the error is serious enough that it has a serious effect on basic fairness, integrity, or the public reputation of the judicial process. It's so serious, in fact, that it calls into question the legitimacy of the underlying process, the trial itself. In this case, there was such plain error because the judge included in his instruction the element of proximate cause to the civil battery count when there is no such element under Ohio law. The trial court must give jury instructions that correctly and completely state the law. In addition, the instructions have to fairly state the law that's applicable to the evidence presented at trial. When it's so misleading, as in this case, that it prejudicially affects the substantial right of the complaining party, the appellant in this case, it is plain error and it should be overturned. Now, the counsel in this case had presented their own jury instructions before trial, as is common, but Judge Collier, as he often does, did his own jury instructions. He handed them out to counsel at the same time that he was beginning to read them to the jury, so there really was no opportunity for appellant's counsel to object.
Was there an attempt to object?
My understanding is that there was not. I was not at the trial. But my understanding is that counsel was trying to read the instructions and go through them as he was
As the court was,
reading to the jury.
but counsel did not ask for a sidebar or did not do anything to try and bring the court in?
I don't believe so, Your Honor.
Okay, thank you.
And is there a transcript? Will we have a transcript of that portion of the trial?
No, Your Honor, there is no transcript.
So that,
Which for plain error review, our position is transcript's not needed when it's plain error. It's a plain error of law to instruct the jury improperly.
well, but I think that plain error really does not speak to the appellant's burden to provide evidence from the record upon which its assignment of error is based. It excuses, to a certain extent, the appellant from having failed to object, but it doesn't mean that the court doesn't need to see what it was that the court said, because the court, you're saying that there was not time, but the transcript could have shown that the court said, well, I know I'm reading these at the same time that you're reading them, but we're going to take a 20-minute recess for you to be able to review these, and I'll give you an opportunity to make any objections. And we don't know that because we don't have the transcript. And you don't know it because you weren't there.
I wasn't at the trial.
Right.
I can tell you, attached to our appellant's brief are the instructions.
No, that I
Given by the
understand.
judge.
Yes.
So we know how the jury was instructed. We know exactly what words Judge Collier used.
If he specifically stuck to those and then handed them to the jurors.
Yes. Well, I know he handed them to counsel, and then he read them to the jurors. I presume he also gave them a copy of his instructions.
But the position that you take is that the counsel didn't have time.
Right.
And that needs to be supported by, or not, by the
Okay. Well, and I would say also normally, counsel submits proposed jury instructions, and then there's any objections to the other party's instructions would normally be heard, and that would be decided before the judge decides on the final instructions to the jury. In this case, the instructions just came out from the court, you know, here you go, and started reading them to the jury. Now, with respect to the instruction itself, when we talk about civil battery, we know that civil battery occurs when a defendant intends to cause harmful or offensive contact, and in fact does cause harmful or offensive contact. We cite to the case in our brief of Angus versus Ventura. It's a 9th District decision where just the act of spitting in someone's face was deemed to be actionable civil battery, and there were substantial damages awarded in that case, just from the fact that there was saliva on the face of the person that had been assaulted by the battery. I think the part of the confusion in this case may have been because the court was using some of the OJI instructions, as is common. And there were both negligence claims and claim for civil battery. So if you look at the Ohio jury instruction, section 405.01 for negligence, it very clearly does state that there is the separate element of proximate cause that must be established. Civil battery, however, in OGI section 429.03 merely says battery is intentional, unconsented contact with another. No other elements are mentioned. And then the comment on that instruction, it says a battery may occur without actual physical harm. So, and we also cite case law as well to establish that when you're talking about civil battery, the damages are presumed. The wrongful act itself, in and of itself, is the damage. Now, because there was a negligence claim, the appellant did provide extensive testimony to the jury that he was damaged. He presented expert testimony. There were medical bills, other medical evidence that was submitted. Therefore, he certainly satisfied his burden to show damages with respect to the negligence claim. And to the extent there's any question as to damages on civil battery, he did establish that he was damaged through medical evidence and through expert testimony.
So the negligence claim, as I recall, was decided in favor of Mr. Ashley.
Correct.
Okay.
But the jury did find that he was liable for civil battery.
But found that there was no probable cause. There was nothing to connect it to.
Right, because it was sticking to the jury instruction and having to find proximate cause, it never got to the issue of damages.
Mm-hmm.
So we did have a finding of liability, though, as for civil battery, which leads me into the next point that's on appeal, and that is the abuse of discretion in failing to award costs as a prevailing party. Tyler Kitson was a prevailing party on his civil battery claim. Now, opposing counsel may say, well, counsel signed the jury verdict form. Why did they do that? I would say that it's a common practice to sign the jury verdict form, and that in no way was any waiver of the right to appeal later. There's no way to object to final judgment entry by refusing to sign the jury verdict form. You actually must file an appeal, and that's what Kitson has done in this case. Under Civil Rule 54D, except where a provision of a statute or another rule would provide otherwise, costs shall be allowed to the prevailing party. It says shall be allowed. And we know from the Ohio Supreme Court's holding Advance versus Rondersheimer, if I'm pronouncing that correctly, at 64 Ohio State 3rd 552, the phrase, unless the court directs otherwise, simply means that the court has discretion to allocate cost to the prevailing party, either all or some of the costs. But there's no authority for not awarding any cost to the prevailing party, which is what happened in this case.
So if the court finds, just in a hypothetical case, that there is liability, the plaintiff testifies as to the damage, and even under the standard that you cite for battery that does not include proximate cause, the plaintiff testifies and the court finds the testimony to be wholly incredible, the court is required to grant damages. Is that your position?
You mean if the court finds that there was no evidence that the battery actually occurred?
No. That there is liability, legal
Okay.
liability,
Right.
but just disbelieves the testimony with regard to whether an injury occurred.
Correct. I mean, you're correct. I think the jury could find liability, but then find no damages. However, what we're talking about here are costs. As a prevailing party, because he was determined to his claim for civil battery was upheld. The jury did find that Mr. Ashley was liable for civil battery. Just even if they found no damages, he's still a prevailing party.
Well, and are we limited in review to just the battery? Are we isolating that, or are we looking at the negligence and the other charges or the other causes of action that were directed out in making a determination as to who was the prevailing party? Don't we take a more global view?
I don't believe so, Your Honor. Our contention is you can be a prevailing party as to just one claim in a multi-claim, multi-count lawsuit. And in fact, we provide some authority in the brief to the extent that it doesn't depend on your degree of success at different stages of the trial, but whether at the end of the day, the party who makes a claim against the other has successfully maintained the claim. In this case, Mr. Kitson did assert a claim for civil battery. Mr. Ashley was found to be liable for civil battery. And there should have been some costs awarded based on the fact that he was a prevailing party as to that claim. And he had significant costs. He had costs, I believe it was well over $1,000. And if you look at Superintendent's Rule 13D2, it says that the reasonable expense of recording testimony on videotape, the expense of playing the videotape recording at trial, and the expense of playing the videotape recording for purposes of ruling on objections shall be allocated as costs in the proceeding in accordance with Civil Rule 54. And of course, 54D is the rule that says that a prevailing party shall be awarded costs unless there's some statutory provision or rule that would provide otherwise.
And counsel, you wanted to save some time, right?
Yes.
Okay. So you're at 3 minutes, if you want to say.
Thank you very much.
Good morning, Your Honors. My name is Lavelle Payne, and I have the pleasure of appearing before you this morning on behalf of the appellee in this matter, Mr. Christopher Ashley. In turn, I'll address the 3 issues raised in Mr. Kitson's brief. I'll go ahead and start with what opposing counsel started with, the proximate cause issue as related to civil battery, and move from there to the question of the motions for cost, and finally address the motion for leave to file answer. As a threshold matter, when plain error is alleged, it's almost necessary that a transcript be presented to the appellate court. Otherwise, absent the information that you have, which is simply the jury instructions, like Your Honor said, there's no way for you to know whether or not the contentions put forth in the appellant's brief are in fact correct. I tried this, yes, Your Honor.
But as I understand it, your argument for the necessity of a transcript solely relates to whether or not sufficient time was allowed for objections, that sort of thing.
In this brief, Your Honor, yes.
Yes, that's what I'm saying. So his point is, so what? Because it's a plain error analysis. Everybody agrees there was an objection, whether you had time or not. Isn't that irrelevant?
On its face, it could be, yes, Your Honor. However, I think what's really important here is that the contentions that they're making surrounding the jury instructions aren't actually addressing the question of the definition of battery that was given to the jury. The first thing the jury was told was that battery is intentional, unconsented contact with another, period. That's what the jury was told the definition of battery was. The secondary analysis as to whether or not my client, Mr. Ashley, owed the defendant and was liable in some monetary way to the plaintiff, Mr. Kitson, was the second question asked of the jury. So first, the jury was asked to determine from the greater weight of the evidence whether the defendant actually committed a civil battery. That's the first question. That's, as you walk into the door, whether or not a battery actually occurred. The secondary question to that is, if in fact you did find, and 7 of the 8 jurors did find, that Mr. Ashley committed an unconsented intentional contact with Mr. Kitson, is there a proximate cause between that and the damages? That's where the true question of liability comes in these civil actions. It's not, as counsel said, well, if somebody spit on somebody, there is a presumption of damages there. That was not the case here. This jury had the opportunity to hear testimony from the plaintiff, Mr. Kitson, from his treating physician. They heard testimony from the defendant and had the opportunity to review all of the medical records. They determined, the finders of fact determined, that there was no damage here. So whether or not this actual battery occurred.
Did they determine that there was no damage, or did they determine that the damage was not proximately caused by the battery?
Well, looking at the situation globally, the findings, and they were not filed with the record, Your Honor, but there are jury questionnaires, there were interrogatories posed. And under the negligence, there was a question of whether or not there were damages. There were not, under that heading. Now, we are, in fact, looking just at battery. So the question was whether there was proximate cause for the damages, and the jury found that there was not.
And to that point, the OJI instructions don't really speak to proximate cause. I was trying to find it in the brief, but rather something that's like reasonably related. I don't recall the exact language, but it seems to be a lesser burden than the burden that the trial court gave.
Your Honor,
understand my point?
I think so. If I'm understanding you correctly, essentially you're saying that if there is battery to be found, then rather than, I guess, the preponderance of the evidence, there's something less than that for battery.
Right.
And Your Honor, I think that even that standard was not met here, and the jury was able to see that quite clearly. Even examining the question, simply was there proximate cause for an injury? Having viewed all of the evidence globally, this jury determined that that was not the case. So even if that standard was lower than your preponderance of the evidence, this gentleman failed to meet it at the trial court level.
Well, but how do we know that if the court gives an instruction and then tells the jury, as you know, we have as trial judges for years, that you are instructed to follow these rules that I'm giving you, and I'm telling you that these are the elements that you have to find. And the jury goes in and says, well, one of the elements is proximate cause. Okay, that means direct cause, as opposed to some cause that could be remote. Isn't that putting Mr. Kitson at a disadvantage legally where the jury instruction should not have done so?
Well, Your Honor, I don't believe so. I think there's case law stemming from this court that's included in my brief that illustrates that, like negligence, intentional torts still have questions of proximate cause and damages. So although the first half of the statement is, was there an intentional unconsented contact with another, you still must find that causation. And the case law actually does say proximate cause and damages, or proximate cause for damages. Therefore, I don't think that matters here, Your Honor. And moving on from that to the question of the motion for costs, I think here again, the case law that was cited was something to the effect of, well, if there is battery, then there is civil liability, and therefore this is the prevailing party. But Your Honor raised the point. There were 4 causes of action brought here. Assault and intentional infliction of emotional distress were all dealt with at the interim after plaintiff's case in chief. So technically, if we're looking at all the causes of action here, that's 2 before the defense even put on our case in chief that went in Mr. Ashley's favor. Then there's the question of negligence, which also was decided in Mr. Ashley's favor by the jury. And then finally, the ultimate question of liability for the battery was also decided in Mr. Ashley's favor. So if we're stepping back and viewing this case from a global perspective, Mr. Ashley was in fact the prevailing party. So there's no question here, although Civil Rule 54D is very clear that the court may otherwise direct. So in looking at this and examining the question of whether the court abused its discretion, we're looking at whether they acted in an unreasonable, arbitrary, or unconscionable way. And globally looking at the entire trial, at all of everything that happened here, no, that burden's not met. There's nothing in the record that demonstrates that Judge Collier acted in any way that was unprofessional at all, let alone unreasonable, arbitrary, or unconscionable. Moving on to the motion for leave to file answer. There was, again, this is subject to the abuse of discretion standard, not a de novo review. So in appellant's brief, there was substantial facts that were essentially a repetition of the briefs that were discussed when the court reviewed all of the briefs in a non-oral hearing on May 6, 2015. Now the journal entry detailing that hearing and the findings therein is included in the record. And what the court will note is that there were 10 briefs filed related to that issue. And the court said, upon consideration of the plaintiff's motion for default judgment, or in the alternative for summary judgment as to liability only, and the numerous related briefs, the court finds the motion not well taken and therefore denied. So essentially, what the court's done is outlined for us what they considered and the fact that they reviewed all of the information to determine that there was in fact excusable neglect in order to allow the answer to be filed. Now, what plaintiff is, appellant is essentially stating is, well, we don't agree with what the trial court said. But what the transcript of the docket will show is that there was no motion for reconsideration, there were no objections filed with the court, and we simply proceeded along the docket. So essentially, whether the court made an unreasonable, arbitrary, or unconscionable decision in allowing the answer is also, should be decided in the negative, and the court should be affirmed on that issue as well. Are there any other questions?
I don't believe so.
Thank you for your time.
Okay, first with respect to the instruction itself. If you look at the instruction which you have attached to the appellant's brief on battery, it does say, if you find from the greater weight of the evidence that defendant committed battery against plaintiff and that battery approximately caused the injury herein, then you will determine what sum of money will reasonably compensate the plaintiff for that injury. I don't know how you separate approximate cause when it says and. Clearly, it did not matter to the jury. The jury would not think that it could award damages unless it found proximate cause, and that's exactly how the judge instructed the jury.
You agree that there were interrogatories that were propounded?
There were jury interrogatories.
Wouldn't it have been helpful for this court to have those as part of the record to try to determine whether there was error that had some effect on the jury?
It may have been, Your Honor. I mean, I don't know that any of the jury interrogatories would have gone to proximate cause, but I mean, I understand that could have been helpful.
Yeah.
It could have been helpful. I can concede that. My opposing counsel also does not cite any cases that establish, as a matter of Ohio law, that proximate cause is in fact an element of civil battery. She argues that, but I'm wondering where the authority is, because we're certainly aware of no such authority. With respect to filing the answer almost 6 months after it was due, it's very clear, and I did not get to this part of the argument in my main argument a few moments ago, but it's very clear under Rule, get to that point here, I believe it's 6B2, a late filing can only be accomplished upon motion and where the failure to act was the result of excusable neglect. And of course, under Rule 15A, you have 14 days to answer upon being served with an amended complaint. In this case, they didn't even argue excusable neglect. Their excuse was that they thought they didn't need to file another answer because they felt like the amended complaint was close enough to the first complaint that they didn't have to do anything. Which, frankly, if you look at the two complaints, the first complaint did not even have Ashley as a defendant. It didn't have any civil battery or negligence claims. It was a right to participate case initially. So the case was against GFS, the employer, and the BWC. So the two complaints were nothing alike. There were many, many allegations and additional claims. But that was the only excuse they ever offered up. They never argued that it was excusable neglect. And the court never made an express finding of excusable neglect either. So the only reason we went to trial, we should have had default judgment. The only reason we went to trial is because the judge did allow them to file their answer and to contest the claims 6 months late.
And counsel, you're out of time.
Okay, thank you.
Thank you. The court will take the matter under advisement, and a written opinion will be sent to both sides as well as released on the website. Thank you very much.